Mr. Speaker. I'm pleased to be given the opportunity to join my colleagues and comment on the Criminal Procedure Reform and Modernisation Bill, which is a very significant bill, not necessarily just as indicated by the size of the bill itself, but the really weighty issues that it addresses and the fact that it does touch on some of our most sacred elements of our criminal justice system, which is why Labor is very cautiously supporting this bill through to select committee so that we have the opportunity to give it the really hefty consideration that it deserves. And I think that probably from our perspective as a party, there will be a couple of really key principles that we will be keeping in mind when considering the content of this legislation. And these are the core principles that we take into account when considering most pieces of justice legislation. They are first and foremost the notion of access to justice, that our criminal justice system keeps in mind its interface with both a defendant and also a victim. And that means that justice should be speedy and efficient, but that shouldn't compromise the second really core principle, which is the importance of public confidence in our criminal justice system. I would hope that each and every one of us in this House would approach justice legislation with the view that we may one day, or could be one day, or keep in mind the perspective of both a victim and the potential of one day being a defendant, because we simply cannot side with either on when considering criminal justice legislation, because we must ensure that both defendants and victims are kept in mind for when considering such weighty pieces of legislation. And I fear that we may not be doing that in some of the provisions that we're seeing early on, and so we do approach this bill very cautiously. And I want to touch on some particular elements of the bill. But before I do that, I want to just reflect on some of the context of this bill. It has been developed after some quite hefty consideration. And in the past, in fact, the Ministry of Justice has acknowledged that our current system suffers from excessive cost, excessive complexity and excessive delays, which of course has an impact on defendants, victims and other participants. But as my colleague Lynn Pillay mentioned earlier on, there have been other opportunities for us in this House to deal with some of those matters through other initiatives that have not been taken up, some that are far less controversial. I believe it was a bill relating to family court matters, which gave the option of a family court judge using judicial officers to clear some of the caseload that they're facing. And of course those cases often involve children, and so speed is much more important, or even more so than usual in those cases. And yet that bill, which has been passed, that power which is available to them, is unable to be used because the government did not believe it was something that should be enacted. And I do find that disappointing. In fact, Justice told us it was not a priority, and yet that could have aided in removing some of the excessive delays we're seeing in our court system. And I also would have thought that the Ministry of Justice probably would have made the point about complexity, delays and excessive cost if they had been given the privileged opportunity to be the advisors when we considered the three strikes legislation. But of course, as we all know, for some bizarre reason, it was the police who advised us on that important piece of criminal legislation. It is extraordinarily odd, and I would wager that's because the police were some of the few, the very small number of groups who were in support of that legislation. The Ministry of Justice, I imagine, would have advised against it. But coming back to this particular bill, which results from the Criminal Procedure Simplification Project, which was established in October 2007 and was a collaborative piece of work between the Ministry of Justice and the Law Commission, we have seen a series of quite controversial recommendations come from that, be translated into this bill that we're considering. And in fact, pointing directly to that is the fact that the Attorney General, Chris Finlayson, has released quite a scathing report on this bill, saying that in a number of ways by allowing criminal trials to proceed, in particular without the accused being present, and by allowing the courts to order the retrial of an acquitted defendant if news evidence comes to light, is in contravention of the Bill of Rights Act, which is interesting given he himself has been one of the individuals calling for drastic reform in our justice system. So to have one of the individuals who have promoted reform then come out against some of these provisions, I think, points to the fact that we may not have got it right on every element of this bill, and we will certainly be applying very close scrutiny to our consideration of that. The fact that even just earlier this year we considered the use of video link technology in our court systems, and it was Labor that very strongly spoke against the idea of having defendants able to access their own court case via a video link. From our perspective, that did not hold true to one of the most important elements of our criminal justice system, the ability to attend your own trial, in a substantive trial, not a procedural hearing. So we will continue to hold that principle when considering some of these proposals. I want to touch very quickly on some of the most significant proposals, some of which have been canvassed by my colleagues. And one, which I've already mentioned, which goes to the heart of the New Zealand Bill of Rights Act, is the changing the threshold for jury trials. I heard one member of the House refer, I believe it was Simon Bridges, refer to the idea of using a jury hammer to crack a nut. I think he was alluding to the fact that perhaps we're using jury trials for cases he might consider to be insignificant, relatively speaking. Now, of course, that's taking a perspective from someone who is not obviously a defendant in a case when considering whether or not something is insignificant. When someone is before our criminal justice system, that is significant on every occasion. That will be a significant issue, particularly for that individual. And I think finding an appropriate threshold where we remove that fundamental right is a very delicate thing, and I think that Labor will be considering that proposal very, very closely, as we will with the notion of proceeding with 10 jurors. Now, it was under, I believe, Phil Goff as the Minister of Justice, where we did have some considerable reforms to the way our juries operate in New Zealand, and I think at that point we probably got the balance right. Moving forward to these proposals, I'd like to see some consideration as to whether or not those that we've already gone through have been the success that we needed them to be, and whether or not moving to allow jury trials to proceed on a routine basis with fewer jurors, whether or not that will provide the improvements to our system that the Minister of Justice assumes they will, and I hold a bit of a question mark over that. We then have the defence disclosure of issues, the idea that the defence would have to identify and disclose issues in dispute before a trial. I think probably on the face of it, those listening may assume that sounds like common sense, but I think we have to be very, very cautious in the way we proceed with that significant change as well. Exceptions to the double jeopardy rule, I think the same applies then. Proceeding in a defendant's absence. This bill not only gives the ability for a court to proceed in the absence of defendant when there is no reasonable excuse for that absence, it also gives the power for them to proceed even if there is a reasonable excuse. I'm quite concerned in the same way that we were over audiovisual technology that someone not being present when their trial is taking place, even if they have a reasonable excuse, undermines notions of natural justice, and I think we should exercise extreme caution, again with the notion of a reverse onus of proof. So I've touched on some of the some of the key elements of this bill which Labor will be paying close attention to. Again, those core principles for us will of course be access to justice, and that does include efficiency, but also public confidence. Whether you as a member of the public, Mr. Speaker, whether an individual member of the public be a victim or be a defendant at any point in their lives, our justice system must serve both, and that will be our focus.